Levi Fishlock, you are aged 31 years. You fall for sentence in respect of your guilty pleas to the following crimes, all of which were perpetrated on Sunday, 4th August 2024. Arson with intent to endanger life and violent disorder. The maximum sentence for arson with intent to endanger life is life imprisonment. The maximum sentence for violent disorder is 5 years. You have no previous convictions. You pleaded guilty at an adjourned plea and trial preparation hearing. It was argued that you are entitled to full credit, but having examined what occurred in the magistrate's court, that argument was rightly jettisoned. The inevitable sentence of imprisonment may be reduced by 1/4 by reason of your guilty plea and the stage at which it was entered. I make it clear at the outset that the principle of totality is front and centre of my consideration in this case. I must pass a sentence upon you which reflects your overall criminality, perpetrated on a single occasion, which is both just and proportionate in all the circumstances. It is my view, standing alone and following a trial, these notional determinate sentences would have been justified in the absence of mitigation. Arson with intent to endanger life, 12 years. Violent disorder, 4 years and 6 months. The fact this immensely serious criminality, taken as a whole, was perpetrated in the midst of exceptionally vicious public disorder, which was suffused with racism, whereby you were seeking to harm the many occupants of a hotel who were terrified inside that they were about to die, coupled to the concurrent attack upon the police, makes this one of the worst cases of arson with intent to endanger life of its kind, which has come before these courts. In my judgment, I am entirely justified in moving outside the ordinary range of sentence. You intended that the occupants of the hotel should come to very serious harm, and you plainly participated in a brutal attack upon police who were bravely trying to keep order. I accept you did not start the fire, but you added to it and helped fuel the flames. That is, frankly, as serious as starting it in the first place. You were a leading participant in an ignorant, racist attempt at mob rule. You were well to the fore, indeed you were right at the front, in this truly appalling civil disorder of major proportions. An exemplary and deterrent sentence is necessary. It is also important I do not double count factors, and I have guarded against that. It is my view that following a trial, a notional determinate sentence of 14 years would have been passed upon you, having regard to personal mitigation. That sentence reflects overall criminality by reference to the principle of totality. You not only committed the crime of arson, but there were other serious acts of violent disorder. It is my view I should further reduce the sentence because you have no previous convictions. It is my view that if you had forced a trial, the determinate sentence would have been 13 years in all. In reaching that sentence, I have taken into account all of the mitigation beyond the guilty plea. As you have pleaded guilty at the PTPH, the custodial element of the sentence must be reduced by 1/4. This takes the custodial element to 9 years and 9 months. I have then stood back to assess whether any further reduction is warranted, having regard to the principle of totality. In my judgment, there is a need to round down that term further. I shall round down the custodial term to 9 years. That is the just and proportionate term in all the circumstances of this case. I shall then extend the sentence by 5 years for the protection of the public. The full extension period permitted by law is necessary in this case. For the avoidance of doubt, although the entirety of the violent disorder was racist, I am required to indicate the uplift by reason of that factor. I adjudge that to be 6 months in this case in respect of the concurrent sentence for the violent disorder. Sentence. You must now stand. The sentence I pass upon you, in total, is an extended sentence of 14 years. The custodial term is 9 years. The extension period is 5 years. I shall pass that sentence on the lead offence of arson with intent to endanger life. It reflects overall criminality. The individual sentences are as follows: arson with intent to endanger life, an extended sentence of 14 years in the way I have just explained. I repeat, that reflects overall criminality. Violent disorder, 3 years, 4 months imprisonment to be served concurrently. The necessary statutory charge is imposed upon you with the appropriate ancillary order. I have decided not to make you the subject of a criminal behaviour order, as I am imposing an extended sentence upon you. It is much better the parole board control your behaviour in due course for the entirety of this sentence. You will in due course be released on licence. If you breach the terms of that licence, you may be recalled to prison and you may be required to serve the entire term. I repeat, the total sentence is an extended sentence of 14 years. Take him down.